Well, I think we're ready to resume. Mr. McBrearty, did you have anything you wish to add before you finish your submission?
Very briefly, my lord, if I may. First of all, on the question of recklessness, might I just give your lordships some references to the bundle on the question of whether this was raised as a ground of appeal here and also in the court below. Your lordships will find it in the grounds of appeal which formed part of the application to this court. Both the issue of law, recklessness is the issue of law, and as an issue of fact were raised in ground of appeal 2. 2 sub Roman 1 deals with the legal issue, and Roman 2 deals with the factual issue. That's at MS 11. And the background to that having been formed part of the permission for the application for permission from this court was that both the issue of law and fact was raised before the First Division, and the members of the First Division expressed different views. And in particular, if I could give your lordships the reference to those paragraphs, the Lord President at paragraph 24, that's MS 209, he reserved his view on the legal issue as to whether or not recklessness was to be equated with a deliberate act. He expressed the view obiter then that, as a matter of fact, he was inclined to think that the facts here did not disclose recklessness, but he didn't reach a concluded view on it. Lord Brodie at paragraph 54, that's MS 229, he indicated that he didn't deal with the legal issue, and he expressed the view that the matter didn't arise because there was no finding of recklessness. So I accept that he appears simply to have gone with the Lord Ordinary's view that there was no recklessness. Lord Drummond Young at paragraph 68, that's MS 238, expressed the view that there was possibly recklessness. And it was against that background of the inner house not having dealt with the legal issue and having, in a sense, expressed differing views as to the possible factual basis for recklessness that the matter was raised in the application to this court. I accept, of course, that within the statement of facts and issues, in the sense the recklessness issue is encompassed within issue 1, because it's simply a question of whether there was a deliberate act, recklessness to be equated with deliberate. But it was against that background of the differing views that the permission from this court was sought in relation to both the legal and the factual issue. And of course, I accept that asking this court to deal with any factual matter of this is unusual, but nevertheless, the court did grant permission without exception, including the matter of the factual matter. The only final observation I would make, my lords, is that the discussion this morning very much focused on clause 14. And of course, I simply remind your lordships that even if your lordships were against me on clause 14 in my submission, that doesn't detract from the force of the argument in relation to extension 3, because the First Division's essential error on that front was to regard extension 3 as giving rise to liability, cover in respect of liability arising only out of an action for deprivation of liberty. And that is, in my submission, effectively a legal error on the basis of the construction of the clause. And if your lordships then are against me on clause 14, but with me on extension 3, then in my submission the appropriate disposal would be to allow the appeal but to remit back to the Court of Session, because the respondent would effectively have a live claim, but subject to the limitation of liability of £100,000.
Thank you very much, Mr. McBrearty. I think then we can turn now to Mr. Milligan.
Yes, obliged, my lords. Just to give some indication of how I propose to structure this, I will obviously follow very largely the written case in 7 major parts. The first part being to look at what is the point of this policy, and in particularly the public liability element, because in my submission, that's what really holds the key to construction in this case. Secondly, I'll look at the applicability of the contract. Now, although I accept that that's not an issue, it's accepted that the contract applies, it is important to look at the difference between the question of whether the contract applies in the first place, and secondly, once it does, whether there are terms of it that are excluded. And in that context, Gray against Barr or grey and bar becomes much less relevant in my submission. Thirdly, I'll very briefly look at the nature of the injury and the liability. Fourthly, I will look at how Clause 4 operates and give two possible constructions, the second of which certainly seemed to be very much in line with what Lord Briggs was envisaging earlier. Fifthly, I will deal with the question of whether the words deliberate acts can really be interpreted to include reckless, or read in the words or reckless. And obviously, I will suggest that the reasoning on that is fundamentally flawed. Sixthly, I will look at how Clause 14 applies on the facts of this case. And finally, I'll look at Extension 3 and Clause 20, which has not really been mentioned so far, but Extension 3 only makes sense, I would submit, when read together with Clause 20. It's effectively a limitation clause rather than an extension. So if I can come back then to that starting question of what is the point of this policy, and I would start with the totally uncontentious suggestion that effective insurance is highly socially desirable. It is something that is required to spread losses effectively, to distribute where those losses fall, so they don't just lie where they fall, in this case with a widow and her child. And they also allow businesses. Yes, question?
This is a theme of your submissions that I have difficulty with, Mr. Milligan. I mean, this is a commercial bargain. Unless there's some legal obligation to have insurance where it might be relevant to consider its social utility, it's simply a matter of what the parties have agreed. And there isn't some principle that it's a good thing people should have cover and therefore we interpret their policy as applying. It just depends what bargain they've struck.
Well, in my submission, there are wider policy implications for this type of insurance. And that's something that was recognised by the Court of Appeal in Hawley and also by the Inner House, and in my submission, correctly so. And one of the reasons for that is that an employer of an independent contractor will very often want to check the terms of an insurance policy for that independent contractor. So it's not simply a bilateral situation. There are other parties involved. First of all, there's the employer of the independent contractor. And in this particular context, as we can see from the facts of this case and in Hawley, there's also the general public who are affected by the efficacy of the insurance. So with the greatest respect, I would fundamentally disagree with the suggestion that this is simply a bargain between two parties. And if one of them manages to sell the other one a pup, then that's they've won, and it's as simple as that. Can
I ask Mr. Milligan, in the Hawley case, mention was made of a registration scheme operated by the local authority, and it really arises from Lord Leggett's question. It occurred to me to wonder whether this is a regulated industry in which public liability insurance may be a condition of registration. I don't know.
Well, funnily enough, the Lord President raised that very same question in the Inner House, and it was simply left open as to whether that was the situation or not. I think there was an indication that those instructing my learned friend would clarify the position, but ultimately it wasn't. The short answer, therefore, is I don't know, but it's certainly something that in my submission, any sensible club owner employing, looking to an agency to provide door stewards, the first thing they would check would be whether they actually have insurance. And just as an illustration of that, there's the case of Gwilliam that I've put on the supplementary list. I don't think I really need to take your lordships to the actual fact of the case beyond reminding them that that's a classic example of a situation in which the Court of Appeal held that there was a duty on the hospital when having a fair on their grounds to ensure that there was contract in force, but crucially, not to check the terms of that contract. It was sufficient to make sure that there was insurance in force. And the difficulty of the situation that we have here is that what certainly the interpretation at its broadest urged upon this court would strip this policy of any realistic content at all. And I think Lord Briggs mentioned this earlier, and it's clearly the case. And my fundamental point here is that misleading insurance, ineffective insurance that gives the impression of providing cover, which in fact it doesn't, is worse than no insurance at all, particularly in this context. Yes,
sorry, I don't understand your concept of misleading insurance. I mean, we interpret what the policy means, and if that's what it means, then that's its effect. We're not going to interpret it as saying one thing and meaning something else. I mean, there's no space there.
I mean,
misleading insurance.
Misleading to third parties who think that there's insurance in place because ostensibly there is, when in fact that insurance has no content, which is what I say is the position here. Or in the situation of Gwilliam, where there was insurance that had just run out. Or
if they want to know what the cover is, they ask to see the policy, and if they want help, they ask for a legal opinion. And if the lawyer says it's unclear and you have to go to the Supreme Court to find out the answer, then that's the answer.
Well, interestingly, the court in Gwilliam held that wasn't, the duty was to check insurance, but not actually to check the terms of the insurance. So
I wasn't suggesting a duty, I was just saying if the third party wants to know, they can ask to see.
Well, they can, and whether the ordinary member of a bar in Aberdeen would be able to make head or tail of what is actually achieved by this is open to conjecture. But I would suggest that it's going to give a misleading impression that the provider of the door steward has £5 million worth of cover that will apply in the, as it were, the standard situation that one would expect a policy of this type to cover. And it doesn't, apparently. So that's what I mean by misleading, my lord. And I think, in fairness, it must be the situation. And I'll perhaps move on now to the applicability of the contract, because it is accepted, both in this court and the court below, as it was in Hawley, that accidental injury is habile to cover deliberate acts of employees. There's clearly a difference between burning down your own house and having your house burnt down by an employee who bears a grudge against you. But what we're dealing with here is not whether that contract is enforceable in the first place, it's whether the insurer can rely on an exclusion clause to defeat what is, as it were, the primary purpose of that insurance. And the primary purpose of insurance when it comes to door stewards is quite clearly to cover physical confrontations with members of the public, which to some extent at least are almost inevitably going to be physical. Now, I accept that those of us on the screen probably don't regularly visit premises to which access and egress are regulated by large men in black puffer jackets, but I'm reliably informed by my student-aged children that in such premises, it's not unknown for there to be physical confrontation between staff and customers, particularly ones who are to some extent inebriated or intoxicated. So that is precisely what one would expect a policy like this to cover. Now, the appellants suggest that there are situations where there might be some form of accidental injury, and the policy would cover those, and that may well be right. But for the vast majority of situations, certainly on the interpretation urged upon this court, there would not be cover, and the policy would be very largely ineffective. Now, when one looks to the cases on vicarious liability, and particularly, obviously, there have been interesting recent developments in this court in this context, and it has been expressly accepted and recognized that the role of insurance is very important in this context, because it does allow for that distribution of loss. And that's an important factor, so that it's recognized that the employer being insured is more likely to have the means to compensate the victim than the employee. Yeah, yes, Lord Leggett.
I'm sorry to be taking such exception to this line of argument, Mr. Milligan, but if you want a policy that guarantees cover in this situation, then you pay a bit more for one that doesn't have an exclusion for deliberate acts.
I fully accept that, my lord, and if, as I say, if it was simply that bilateral situation in which the insurer could laugh all the way to the bank because they had sold a policy that had no effect, then that might be one argument. But here we are dealing with a very different situation.
Well, it isn't a policy with no effects on any view, because a lot of occasions will be negligence. And so the question is, you know, what was the bargain? And we're not in a position to say a priori whom it should favour. We just have to see what they agreed.
Well, in my submission, in interpreting a contract, it is important to see it in the context in which the bargain is struck, and the wider context of it. But
speaking to wider context, I've checked just now online, and there doesn't appear to be any requirement for insurance under any regulatory scheme. There is something called the Security Industry Authority, but it licenses the individual doorman and focuses on identity checks and training. And there's also something called the Approved Contractor Scheme, also run by the government, but just for the employers. But it doesn't require them to produce evidence of insurance. So it looks as if it is a bilateral contract simply between the security company and the insurance company.
Well, in my submission, there is still that wider context that is relevant in interpreting the terms of the clause. And although I don't want to be thrown back onto the contra profferentum rule, because it always sounds a little bit like a last resort, it is significant here, and where clearly there are a number of differing interpretations possible in my submission, that too is a relevant factor in interpreting the clause, and whether it should have the very wide definition given by my learned friend, or whether a narrower interpretation should be given. If I can turn now to very briefly to the question of what is the injury and what is the liability that this insurance policy is covering, and what this case is covering. in my submission, it is important to bear in mind that this is not, as it were, a claim on behalf of the deceased, of the person who was involved, who was the victim of the direct victim. It is a derivative claim by his widow and young son. And so when it comes to certainly the question of a wrongful arrest, of course, that would be a claim on behalf of the deceased or his estate, and the pursuer in this case simply wouldn't have title to make that claim at all. If I can move on now to the key issue, which is how clause 14 operates. And the court has been given the very broad interpretation favoured or urged on it by the appellants. In my submission, there are two perfectly workable interpretations which are supported by precedent, by policy, and also by policy. The first of those is simply to say that when questioning what is the deliberate act, the act in question is causing death. My fallback position is that if it is the performance of the neck hold, then the requisite intention must have been at least to cause serious injury. And this, I think, comes back to Lord Briggs's suggested middle ground between any injury at all, no matter how trivial, being sufficient to trigger the exclusion clause, and my submission that only the actual act itself should do so.
Mr. Milligan, I was simply inquiring whether your opponent was contending for a middle ground. I don't think you should assume that I'm positively contending for one myself.
I take that on board, my lord. I was perhaps being over-optimistic in that respect.
Lord Hamblin.
In relation to the first way you put the case, if it's not a case of death but injury, what act has to be intended?
The act of causing death.
No, if it's not a death case, an injury case,
yes.
Differentiate between different injuries or not?
Yes, I would say it was the act of causing that particular injury.
That particular injury?
Yes.
So you actually could have specific intent to cause the specific injury, broken nose.
Yes.
Black
yes.
eye.
There might be a range for that, and the greater might include the lesser. So it's an intention to punch somebody and break their nose that causes a black eye instead would be sufficiently similar.
So it's the specific injury and similar injuries.
Yeah.
Similar in severity. Or,
yes.
Okay.
Looking at the first of those possibilities, and the question of what is meant by deliberate act, I'm happy to go along with my learned friend's suggestion that willful default can, in this context, effectively be treated as a synonym for deliberate. What I cannot accept is a suggestion that by watering down willful, you can then turn deliberate to mean something other than what it clearly means, and that is deliberate. I'll come back to that perhaps a bit more in the context of whether it could possibly include reckless as suggested. Now, the approach that I'm primarily suggesting is the one that was adopted by Lord Brodie in the Inner House, and we can see that perhaps looking briefly at paragraph 53 of his opinion, which is at MS 228. And what he says is that your lordship in the chair proposes as a proper construction of deliberate acts where it appears in exclusion 14 the doing of something with the deliberate intention of bringing about a particular objective, namely the loss liability for which there would otherwise be a liability to indemnify. I respectfully agree. It appears to me that that construction gives full weight to the ordinary meaning of the various words in the expression liability arising out of deliberate acts. It avoids absurdity without the need to read in words which do not appear in the text. It is commercially sensible in that it provides cover against risks incidental to the insured's business while being consistent with a basic rule of insurance law, namely that a contract of insurance does not cover an assured against his deliberate or willful infliction of loss, at any rate in the absence of express, stipulate or necessary implication. And of course, it was also the approach adopted by the Australian court in Clayton, and I appreciate that we have looked at this already, but there were certain paragraphs that weren't looked at, and I think it is, being the case most obviously in point here, it is worth looking at again. So if I could ask you to look at MS 208. Oh, no, I apologize. It's 281. Paragraph 7 simply repeats the well-known dictum from Beresford that we've already looked at. And then moving on to 283, it's paragraph 8 that I think is particularly helpful in this context, where it said, no authority has been brought to our attention governing the interpretation of a clause in identical terms with the clause under consideration. 2 American cases were cited in Hanover Insurance Group and Cameron. The clause excluded bodily injury or property damage caused intentionally by or at the direction of the insured. The Supreme Court of New Jersey held the word intentionally denoted that the actor desires to cause consequences of his act or believes that consequences are substantially certain to result from it. In Aetna Casualty and Surety Company, a clause in a legal liability indemnity policy excluded liability for injury which is either expected or intended from the standpoint of the insured. The Appellate Court of Illinois held that the insurer was not obliged to defend or indemnify in respect of a claim for assault and battery. In doing so, however, it said, citing a passage from Appellant Insurance Law and Practice and the Hanover case, the word intent for purposes of exclusionary clauses, which of course is what we're dealing with here, in insurance policies denotes that the actor desires to cause the consequences of his act or believes that the consequences are substantially certain to result from it. The words in the instant policy differ from those under consideration in the American cases. What is excluded is not intentional damage, but damage caused by a deliberate or intentional act. Nevertheless, the American cases cited illustrate the basic considerations and purposes of insurance law, in the light of which the actual words of insurance must be construed. And then we've already looked at paragraph 13 on MS 283, where it states that I consider that the act contemplated by the phrase deliberate and intentional act is the act of causing the damage. There must be deliberate or intentional causing of the damage to the insured premises. Now, the appellants take issue with the use of the words the damage in that context, but it's quite clearly that's not an error, that's not an oversight or a mistake. That's a very deliberate use of those words. It's not a Lord Leggett.
What do you say is the commercial logic of excluding what one might call precision injuries, where the injury is targeted to achieve a certain, the act is targeted to achieve a certain injury and it achieves its purpose? You exclude those, but not if it causes, if he doesn't quite achieve his targeted result, but something a bit off, then it's covered. What's the logic in that distinction?
The logic is that this type of exclusion should be interpreted as in as limited a way as possible, because it goes against the very purpose of the policy. So if there are any exclusions, they should be interpreted in the most restrictive way possible, and not the very broad approach suggested by the appellants in this case.
But you say it excludes, if you intend to cause grievous bodily harm and you succeed, that's excluded. But if death results by accident, then it's covered. I mean, it seems arbitrary from the employer's point of view. But
it is proportionate. There's a proportionality in that situation between what is being between the act and the exclusion. So it's also far more likely that in the majority of cases it will be a relatively minor injury that's intended, and so as it were, the damage of the exclusion clause is more limited, and it's the serious case where there will still be cover, where cover is most needed. So in my submission, that does make complete commercial sense.
But say an intention to cause a fairly trivial injury will be covered if it causes a slightly more serious one. But as long as you achieve as long as the intended effect is achieved, whatever its level, cover is excluded.
Yes, well, if only a minor injury is intended and only a minor injury is caused, then there's less injustice if the exclusion kicks in that situation. If a minor injury is intended, and in a case like this, there is a very serious injury with repercussions for third parties, then there's much more obvious injustice if the exclusion clause still bites. In the relatively unlikely situation of the bouncer deliberately committing a very serious assault, then it's easier to see why the insurer should be able to avoid liability.
But say it's a minor assault, he deliberately intends it and achieves it, it's excluded.
I accept that. Yeah, I absolutely accept that. I still say that that's undesirable, but it's not as undesirable as the solution proposed by the appellants here.
Thank you.
Yeah, and again, at the risk of using it as a last resort, if nothing else, I fall back on contra proferentum. So that's my primary position. The secondary position is that if deliberate act in this context simply means application of the neck hold, and clearly I can't deny that was deliberate, then what I say is required is more than simply a minor injury but is at least a serious injury. And so that is the middle ground that we discussed earlier.
Sorry, how do you get that out of the language of the policy, Mr. Milligan? And how serious is serious, and how do we get that out of the language of the policy?
Well, in much the same way as there's some ambiguity if we just say any injury, however minor, is caused. At least if there's a serious injury, then one can see whether that is analogous or of the same type as the injury that's actually been suffered. So in the context of a case like this, for example, if somebody intended to cause serious injury and the person actually died, that would still, in the criminal law, that would still amount to murder. So the criminal law doesn't have any difficulty with that, and I don't suggest that the civil law should either.
But injury is a word that's used in the policy, and you can interpret it without too much difficulty, I would think, as an act which is deliberately resulting in injury, which is what is covered under the policy. But degrees of injury isn't a concept that appears in the policy, does it?
No, but it's a control mechanism that as I say, covers the dangers of having too broad an exclusion that effectively hollows out the purpose of the principal policy. The interpretation that's urged on the court by the appellants in this case effectively reduces cover to no more than accidental injury, even caused by employees. And as I say, that would render the public liability element of the policy virtually non-existent. If I can, that perhaps brings me on to the fairly crucial question in this context of whether a deliberate act includes a reckless act, as suggested by the appellants in this case. And for a number of reasons, I suggest that's simply not a permissible interpretation. As Lord Reid said this morning, deliberate is very far removed from reckless in its natural state. So one would have to look for a very obvious wording in the clause to alter that particular meaning. And we've already seen in Clayton how recklessness could only be equated with intention where the result suggested is virtually certain. Now, what appears to be done here is to say, well, deliberate and willful are synonymous. Deliberate is pretty clear in its terms. Willful isn't. Willful can be given different meanings in different contexts. And if we look at other cases where willful has been given a slightly watered down meaning, then we might be able to say that in certain contexts, willful amounts to reckless. And once we've done that, we can then come back to this contract and say the word deliberate is affected by that interpretation of willful in other cases. In my submission, that's completely the wrong way around. And if willful needs to be given content, it's given content by the other words in this contract, and particularly the word deliberate. Now, of course, the courts tend to impose liability more readily for acts than omissions. And again, there have been plenty of cases in this court on that front. And I know Lord Reid put to bed any suggestion that there was a difference between the law of Scotland and the law of England in the case of Mitchell against Glasgow City Council. But it would be very strange if the word willful in relation to the omission was actually given a weaker meaning than deliberate in relation to the word act. So in other words, it would actually be easier to impose liability for the omission than for the act. And all of that makes it fairly obvious in my submission that willful in this context means deliberate. And there's, yes, Lord Leggett.
I don't think you have to make that argument, but I have difficulty with it. Willful seems to me to be aiming at, in the omission context, at something different, which is whether there was a breach of duty or not. It's perfectly consistent to cover, to exclude a recklessness as to whether the person was in breach, was ignoring their duty.
Oh, well,
So have on the terms of acts, what you're concerned with is the harm done by the act, which is a different concept, that not symmetrical.
Well, okay, I follow that. I suppose the point I'm trying to make is that willful in that context cannot be used to, in fact, if it's asymmetrical, that strengthens the view that it can't be used to make deliberate mean something other than deliberate, or to read in the words or reckless, which is essentially what the appellants are asking this court to do. It's the only way that they can read this is to say deliberate means deliberate or reckless. So yes, I accept your lordship's criticism, but the point remains the same. It perhaps should as well deal with the question of exactly what reckless means in this context, because certainly the definition given by Lord Justice Tuckey that was referred to earlier seemed a very watered down definition of reckless, where he said, this is MS 289, paragraph 15. In the CP case. So paragraph 16, recklessness has been variously defined, but if someone does something knowing that it is risky or not caring whether it is risky or not, he is acting recklessly. But more precisely, for present purposes, if the insured is aware that what he is about to do risks damage of the kind which gives rise to the claim, or does not care whether there's such a risk or not, he will act recklessly if he goes ahead and does it. And that's a slightly more strict definition. But in my submission, the definition given by Lord Justice Diplock in the case of Fraser, that I think my learned friend was going to turn to earlier, is more informative. It's at MS 311. at C to D. In other words, it is not enough that the employer's omission to take any particular precautions to avoid accidents should be negligent. It must be at least reckless, that is to say, made with actual recognition by the insured himself that a danger exists and not caring whether or not it is averted. The purpose of the condition is to ensure that the insured will not, because he is covering against loss by the policy, refrain from taking precautions which he knows he ought to be taken. And that in my submission is a more accurate definition of recklessness, as opposed to the suggestion of Lord Justice Tuckey, which sounds little more than negligence, simply doing something that's risky. Now, all of this is extremely important, because if this policy only applies to deliberate acts and not reckless acts, then the interpretation urged by the appellants itself can lead to absurdity, because we could have a situation where recklessness as to serious injury wouldn't engage the exclusion clause, but intention to cause the most trivial of injuries would. So, for example, even a gentle push on somebody who then steps back into the road and is run over by a double-decker bus would engage it, whereas somebody who was threatened recklessly wouldn't. So those are the two related and similar constructions that I would urge the court to adopt. The second of those was the one preferred by Lords Brodie and the Lord President in the Inner House. But clearly that there are certain similarities between them. But the important point in my submission is that although they still give a great deal of content to the exclusion clause, they still allow the overall policy to have some useful objective in, as it were, the majority of cases, and not be reduced simply to accidental injury. Yes, Lord Hamblin.
Two questions. Is it part of your case that deliberate acts include an intention to cause injury of the kind in question? No, it's not a specific injury, but the kind of injury such as death, serious injury, or in English criminal law terms, GBH or ABH. Is that part of your case, or is it limited to specific injury?
No. Well, I suppose the primary case might be said to be restricted in that way, but the secondary case would accept that so long as the injury is analogous, then it would be covered. Right. to the intention, yes.
Okay. The other question is, if it's limited simply to intent to injure, doesn't cover recklessness.
Yes.
Well, why do you say that deprives the policy of all effect or most effect?
No, I don't suggest that. I just submit that illustrates the absurdities in the very broad interpretation urged by the appellants in this case, because even the most trivial of injury will engage the exclusion clause if it's intentional, whereas reckless acts wouldn't be, even if they were reckless as to much more severe.
I thought you had a general point that interpreting it as the appellants contend, focusing simply on intent to injury, not recklessness, would deprive the policy of content, meaningful content. Is that your case?
I would say that still deprives it of content if only very minor injury is necessary. Obviously, if it extends to recklessness as well, then the exclusion clause really does rip out the heart of the policy in terms of public liability.
It's really the recklessness point that you're focusing on in terms of affected content. Is that right?
It is, yes. Yes, absolutely.
Okay.
Obliged. Apologies for not making that clearer. So if I can move now to how clause 14 applies on the facts of this case. In my submission, the conviction for assault doesn't establish any intention beyond an intention to perform the neck hold. And I think this is the point that was caused the court some difficulty before lunchtime. And one of the peculiarities of this case is that although the contract is governed by English law, having been raised in Scotland, the Scots law applies, so English law applies, but the fiction is that it's the same as Scots law unless one of the parties pleads and proves to the contrary. So we do have the rather bizarre situation here where we have terms such as wrongful arrest, which means something very different, I gather, to a Scots lawyer than to an English lawyer. And I'm very grateful to Mr. Weir for educating me on this. But equally, we have to interpret a word like battery, which doesn't exist in Scots law, by reference to Scots law. But as far as ascertaining intention is concerned, Scots law is reasonably clear on this, and have made reference to the case of the Lord Advocate's reference in 1993. Perhaps I can take the court to MS 663. From letter H, where Lord Sutherland, when looking at the test of whether evil intent was required, the words evil intent have an eminently respectable pedigree, being used by Hume when he describes dole or mens rea as that corrupt and evil intention which is essential to the guilt of any crime. It is, however, perfectly possible to have an intention to perform particular acts without necessarily intending evil consequences from those acts. To use the word intention may therefore be confusing in itself. If intention means motive, then plainly it's irrelevant. On the other hand, intention means nothing more than willful, intentional, deliberate, as opposed to accidental, careless, or even reckless, then plainly it is relevant, and that a criminal act cannot be formed other than deliberately. This latter view appears to commend itself to MacDonald and Gordon. If therefore a person deliberately performs an act which would in itself be criminal, then both the actus reus and the mens rea coexist and a crime has been committed. The pointing of a gun at a shop assistant, accompanied by words such as those used by the panel, would undoubtedly constitute the actus reus of the crime of assault. And if these things are done intentionally, as they were done here, the mens rea is also, in my opinion, established. The panel undoubtedly knew he was doing what he was doing, and he knew that what he did would be likely to cause alarm and distress. That is sufficient to constitute the crime of assault. His motive for doing it was quite irrelevant, and therefore satisfied that at least as far as the crime of assault is concerned, the trial judge misdirected the jury in leaving open to them consideration of the alleged offence that it was a joke. So this court does have the difficulty, or rather a learned friend has a difficulty of persuading this court in the absence of any finding in fact as to the intention of the first offender to cause any injury, let alone serious injury, let alone death. Particularly where we have the agreed analysis that what he did was badly executed and not badly motivated. Which comes from Lady Wolf's sentencing remarks, which are agreed as an accurate summary. And also the fact that he believed he was acting in defence of fellow door stewards and to minimise the danger that Mr. Grant posed to others. So in my submission, what we are dealing with here is negligence, pure and simple, wrongful death negligently caused. And it's for the appellants to prove that there was a deliberate act that would bring them within the exclusion clause.
Mr. Milligan, you presumably say, do you, that a finding of the absence of bad motive pretty well excludes recklessness?
Absolutely.
Because whichever of the two definitions of recklessness we've looked at you choose, most right-thinking people will categorize that as a form of bad motivation.
Absolutely, my lord, yes.
Yeah, thank you.
Yes, I don't think there's any suggestion that if somebody had said to the first offender, "You're killing it," he would have replied, "Yes, so what? I don't care." Or, "Yes, that's what I'm intending to do." So, in my submission, the facts of this case simply don't engage clause 14. And that then takes us on to the question of whether exclusion clause 20 and extension clause 3 apply. Now, a note that this case is being presented slightly differently in this court than in the court below, where the two were presented as separate clauses. It may be felt that by effectively conceding extension 3, a more sympathetic result is obtained because the pursuer will at least receive some compensation, even if only a fraction of the true value of the claim. But extension clause 3 has to be read in my submission with extension clause 20 to make sense. Extension.
Mr. Milligan, I think Mr. McBearty accepted that that the extension came in working out what the effect of a policy is. The extension was an extension to the primary liability clause, but it comes before you consider the exclusion. And so if the exclusion operates under clause 14, it operates on the extension. I mean, if you're in the territory of wrongful arrest, then if wrongful arrest is a deliberate act, then liability is excluded. And that's why clause 14 specifically is without prejudice to extensions 1 and 2, but not extension 3.
Yes. But extension clause 20 is the mirror of exclusion clause 20 is the mirror of extension 3, and presumably the concern was that the very broad interpretation given to clause exclusion clause 14 would render exclusion clause 20 odious. Because you can't accidentally wrongfully arrest somebody or falsely imprison somebody? Exclusion clause 20 is MS 144 to 5. The bottom of page 144, wrongful arrest, 20, wrongful arrest, any liability arising from or out of wrongful arrest other than as set out in extension 3.
Yes, so extension 3 is concerned with liability to pay compensatory damages arising out of wrongful arrest. And exclusion 20 excludes any liability arising out of wrongful arrest other than as set out in extension 3. So I don't know well, I can't think offhand of what the liability envisages, but it seems to be concerned to exclude anything that isn't.
I'm very sorry, my lord. I didn't catch any of that.
Okay. Well, never mind. Never mind. You make your submission.
Well, yes, Lord Leggett.
Isn't the way it works that normally only injury is covered, but if you buy the extension, you get compensation in principle for wrongful detention, and that includes assault, which would not have caused an injury. So that if unlawful force was used in detaining someone, that will be covered if you got the extension, even though there was no injury. So it's an extension there, it adds that on.
Yes.
But
damage to reputation might be, because injury is defined as bodily injury.
Bodily injury,
but it could be other forms of injury.
Yes.
But if you're right that that the exclusion doesn't apply to the to the bodily injury, which is what this case is about, then that's the end of the case, and extension isn't going to help the appellant.
Okay.
If on the other hand you're wrong, then the extension isn't going to help you. It doesn't seem to me it arises either way around.
Well, I'm content to leave it on that basis. And,
I wonder, is it really that difficult? I mean, the primary liability clause is imposing liability. This is saying we'll indemnify you for liability arising out of accidental injury, which is bodily injury. And then there's an add-on for liability arising out of compensatory damages arising out of wrongful arrest, because that would go beyond bodily injury. That is an extension of the policy.
Subject to a financial limit.
Yeah, subject to the financial limit. And clause 14 then excludes liability where the liability in question is arising out of deliberate act. And exclusion 20, I presume, is in addition, quite apart from clause 14. Clause 20 is excluding any liability for wrongful arrest, presumably above and beyond the limit specified in the schedule.
Yes. Yes.
I wonder if that's
Yeah, no, well, I'm more than content with that, my lords. So, that brings me ahead of schedule to the conclusion of my submissions. In my submission, properly construed exclusion clause 14 simply doesn't apply here, and the case should be remitted back to the Court of Session in order that the second defender's liability can be assessed and quantified. There is the issue of which act applies here, the 1910 Act or the 1930 Act. I don't need to bother the court with that because it's essentially a matter of agreement between the parties how that will be dealt with. I can perhaps explain that the reference to the 1930 Act actually came about as a result of a request from the defenders that it was dealt with that way to avoid the need to go back to court to establish liability. But as I say, I don't need to bother the court with that. It's a matter of agreement between parties how it will be dealt with, subject, of course, to the interpretation of clause 14.
Yep.
But unless there are any other particular questions I can assist the court with, those are my submissions.
Thank you very much, Mr. Milligan. Mr. McBearty, we return to you then somewhat more rapidly than you might have anticipated.
Indeed,
for any submissions you may have in reply.
Yes, my lord. Well, the first point I would make is just to emphasise that in my submission, what the court is concerned with here is a commercial bilateral bargain between the parties. There is, with respect, no room for any questions of public policy. It is a normal insurance contract in terms of which the insurer provides the cover which it is prepared to provide in return for the premium, no doubt taking account of the risks, and in this particular policy in relation to the risks of the use of physical force. So there's no room for any questions of public policy. Turning to clause 14, my lords, in my submission, there is no room for degrees of severity of injury. And I think my Lord Reid picked up on it, and it will no doubt be apparent to all of the members of the court anyway, but injury is a defined term in terms of the policy. Your lordships will find that at page MS 139. And it means bodily injury, death, illness, disease, or shock causing bodily injury. And therefore, that is the injury which is covered in terms of the insuring clause, and equally in my submission, that is the type of injury which is excluded in terms of the exemption clause at clause 14. And that brings me back to tying that in, of course, the intention to cause injury being the deliberate act. There is no room in my submission for considering a degree of severity of injury which may or may not have been intended. And indeed, it is easy to say that that would become a very difficult policy to work in practice if one were required to look at the degree of severity of injury which was intended. It is simply to be treated as injury as defined in terms of the policy itself. And, my lords, in my submission, in terms of the commercial bargain between the parties, coming back to that point, of course I accept that a relevant background circumstance here is that it is an insurance policy for employers of doormen. And yes, of course, it is to be expected that doormen will use a degree of force necessarily in the course of their duties. But in my submission, the commercial rationale for clause 14 is simply that the insurer is prepared to provide cover insofar as reasonable force is used, because there is no intention to cause injury. But if it goes beyond that and there is an intention to cause injury, that is where the insurer's line is drawn, and that is not a risk which the insurer has been prepared to indemnify in return for the premium paid. And with respect to Mr. Milligan, I'm not sure that, for my part, my submission, there's nothing terribly surprising about that in terms of the cover provided, that an insurer would be saying, yes, reasonable force and the consequences of that, but if there is an intention to cause injury, then that is not cover that we're prepared to provide. The recklessness aspect, my lords, if I just may say this, willful is, of course, the adjective which qualifies the omission or breach of duty. Deliberate qualifies the act. And if I may just pick up on a point that my Lord Leggett raised, in my submission, it is consistent with the commercial rationale of including recklessness that the insurer, if not prepared to cover a reckless act or omission, equally would not be prepared, if they were not prepared to cover a reckless omission, default, neglect, then equally they would not be prepared to cover a reckless act. In my submission, the rationale between the two is the same. Coming back to the example that I gave this morning of the omission in terms of failing to call emergency services, for example, then normally one would not expect that to be a willful failure. But if there were evidence to show that that was a willful amounting to reckless, then one can see the commercial rationale for why the insurer would say, well, I draw the line. If you have willfully failed to act, then I don't cover that. And equally, on the other side of it, if there is a deliberate, reckless act, and the example of the present case is if I were to be accepted on the facts, the recklessness on pressing on someone's windpipe, well, equally the insurer says I draw the line at reckless act. In other words, in my submission, there is no reason to differentiate between act and omission vis-a-vis the application of recklessness. In effect, both go to the state of mind of the relevant actor in terms of the exemption laws, and the commercial rationale would be the same. In terms of the absence of bad motive, my lord, in my submission, the test of recklessness which I commended to your lordships was the one which was set out by Lord Justice Tuckey in the CP case. And in my submission, what that carries with it is an objective element as to the testing of indifference. In other words, if the actor in the whole circumstances is indifferent as to whether or not there will be a bad outcome, then in my submission, then that is sufficient to meet the recklessness element of it. And so I simply make this point that a conclusion that there was something was not badly motivated, in other words, that there was no positive bad motive in carrying out the act which was carried out, does not necessarily, in my submission, exclude an indifference as to the consequences of that act. Somebody may perfectly well be intending to restrain and to do no more than to restrain without an intention to cause, let's say, without an intention to even cause the death or so on, but nevertheless, in the whole objective circumstances, one may perfectly well come to the conclusion that those acts in the whole circumstances were indifferent, effectively, as to the consequences which ensue. The last observation I might make, my lords, is simply as to extension 3, which seems to be causing some degree of puzzlement. And I think I agree and accept the observation made by my Lord Reid as to its purpose, perhaps with one possible addition to that, because if it is, of course, an extension in terms of which the insurers will indemnify the insured in respect of liability for compensatory damages arising from or out of wrongful arrest. But one has to carefully look at the definition of wrongful arrest, which is to be found again back at page MS 141. And I respectfully agree that what the definition of wrongful arrest does is certainly, for one part, it encompasses other forms of injury, which wouldn't fall within the terms bodily injury. It certainly would encompass, and one specifically sees in the paragraph number 2, false imprisonment, for example, libel or slander, which wouldn't be considered as bodily injury. So one has that aspect of the add-on which, if the customer pays for it, the insurer is prepared to provide that degree of cover. But might I also suggest this, my lords, which is that what one sees within the definition of wrongful arrest are acts which would plainly involve physical acts. So the very act of any unlawful physical restraint by one person on the liberty of another involves a degree of physical force, and the assault and battery, which is expressly included within the definition, would plainly involve some form of physical force. And so it seems to be, respectfully, that it's not entirely possible to explain extension 3 simply by reference to non-bodily injury, because one has definitions within there which expressly envisage some form of physical force. And that brings me to say this, is that on, for example, the facts of this case, if your lordships were, even if they were, whether they're with me or not if they were with me on the interpretation of clause 14, but against me on the facts, in other words, if they were unprepared to conclude that there was an intention to injure, then nevertheless, this clause may be apt to include those circumstances where there is some form of physical restraint, but yet without an actual intention to injure, if your lordships follow me. And that would then, just as the non-bodily injury would be the subject of the limitation of £100,000, so would that form of physical restraint, of assault and battery carried out in the course of the attempt to arrest or the attempt to restrain, but without the intention to commit an injury and to cause an injury. And it respectfully seems to me that that would be, in effect, mopped up by that kind of situation. And in my submission, it would make equal sense that that type of occurrence would be subject to the limitation, just as the non-bodily injury, such as the slander, the libel, and so on and so forth, would equally be covered by the limitation. Because it comes back to the situation that, from the insurer's perspective, in terms of this commercial bargain, one might see this as a particularly delicate form of insurance, because the insurer is being asked to take cover here for circumstances, employment of a particular type of employee who it is recognised may require to use, and is likely to require to use, some kind of force in the course of their employment. And therefore, it is perhaps unsurprising that, as part of that delicate balance of risk and premium and the uncertainties that come around with that, that the insurer is effectively, in the overall structure of this, is saying, yes, the insuring clause in principle covers the vicarious liability for the employees. Clause 14 operates so that if there is an intention to injure, that is a deliberate act, and we will not step in to cover there. We expect reasonable force to be used, but we do not cover an intention to injure. And in my submission, that's relatively unsurprising that an insurer would be unprepared to cover, for example, outright frank assault. And then one comes to extension 3, which adds back in the non-bodily injury in the defined and delineated circumstances, but also the possibility of physical restraint giving rise to harm where there was no intention. And that is, in a sense, because all of this is concerned with physical restraint and an attempt to arrest, it is part of that, what might be regarded as part of the normal course of the employment of a doorman to find themselves involved in those circumstances. Apologies, my Lord Hamblin.
You say that there's intended to be cover to cover the event of the use of reasonable force, but might that not also involve an intent to injure, even though the force is reasonable?
Yes, I think that, my apologies, my lord, I think that was probably an unhelpful paraphrasing on my part. I mean, I don't demur from the proposition I made, which is that the exclusion clause at 14 must involve an intent to injure. That is certainly true. Probably phrasing it in terms of reasonable force is an unhelpful gloss to put on it, my lord. It's simply recognising the fact that here we have a situation where doormen are involved in a situation where they inevitably, to some extent, require to use some form of force. And the intention is the dividing line. That's the delineating line. Intention to injure or no intention to injure. Lord Briggs. With apologies, my lord, something went wrong with the sound there.
I didn't mean to break in on Lord Briggs.
Yes, I wonder if looking at clause 14 in relation to wrongful arrest or unlawful arrest helps one understand what it's really aimed at. It might be said that it's part of the main, almost a main part of the job of a door steward to arrest people. That is to say, no, you can't go where you want to go. That is to put some restraint on their physical liberty. But, and the real purpose of the clause 14 exclusion in relation to the wrongful arrest cover lies in doing something which is intentionally wrong. In other words, doing it when you know it's wrong, not just either the act or its immediate consequences. And my Lord Legate raised the possibility that the use of reasonable force might involve some very limited injury that's not of itself unlawful. And I wondered, therefore, if one looked at that analysis of clause 14 as an exclusion from the main insuring clause, maybe deliberate and willful point to an intention to do something knowing it to be wrong. And then if one gets into the area of recklessness, an intention to do something not caring whether it's wrong. Importing that concept of excluding from cover the deliberate commission of a legal wrong, rather than defining the ambit of the exclusion by something which isn't actually necessarily along the same boundary line.
Yes. I think my Lord Briggs may have put the point better than I have put it thus far. I think that that's consistent with the concept of intent, the deliberate infliction, the deliberate intention to do something wrong. In this case, of course, defined by injury, but it is the state of mind of the actor. And of course, I encompass within that submission regarding recklessness, which is indifference. And therefore, it is that recognition that a door steward is bound to be involved in a degree of the use of physical force to legitimate purposes at sometimes, and there's no difficulty with that, provided that there's not an intention, the deliberate intention to cause injury, which would be the cover otherwise provided. And in my submission, that sits alongside extension 3, which provides the additional cover in respect of non-bodily injury, but also encompasses those situations where there may be physical injury, but it's not deliberate, and that's subject to the limitation, because the insurer is saying in return for the premium of £2,800 to cover 57 or 67 doormen or what have you, I recognise that that risk is one that is ever present, and therefore if there is no intention and it's in the course of restraint or arrest, which is a normal part of the duties of the employee, yes, I will cover that, but not in an unlimited manner, taking account of the risk which is bound to arise in this course of this type of employment. I'm limiting my exposure to £100,000. And there is a certain logic to that, it respectfully seems to me also, my lords, because one might reasonably expect that if there's no intention to injure, and it's something that falls within extension 3, then £100,000 would seem to be a reasonable limit, as distinct from the kind of deliberate infliction of injury which one would have excluded by clause 14, which one would expect normally fall into a potentially different category in terms of the damage that would ensue from it.
Lord Briggs's suggestion, I think, resembles a strand in the reasoning of Lord Drummond Young and me in a house, where he paragraph 63, it's page 235, he's been discussing how it's inherent in a door steward's job that he has to use, it's proper for him to use reasonable force in order to remove people who've been asked to leave and won't leave, or to prevent people entering who've been refused permission to enter. That's essentially what his job is. And so liability is only going to arise if there is a use of excessive force. And that might be through negligence, or it might be deliberate. And liability is excluded by clause 14 where it's deliberate.
Yes, although I mean, I would observe from recollection, I'll require to go back to the clause, but I think it's worth bearing in mind. I think that expenses are also, costs are also included, so it's not merely the compensatory damages. So one would, for example, have, if I'm right about that, and I'll just double check that, my lords, but if I'm right about that, then there would also be cover even in a situation where there is no intention, but nevertheless a customer, for example, were to bring an action which were ill-founded, then there would be cover for the expenses. And I don't think that's a meaningless element of the cover which is being provided in the kind of circumstances which door stewards would be expected to deal with. But I don't take issue with the general rationale, as your lordship I think gathers. I don't take issue with that as a general background. Door stewards being required to use physical force, and therefore there being a delineation between that which is covered and that which is not covered. And in my submission, that's to be found. That rationale then finds itself expressed in clause 14 by deliberate act. And as your lordships have my submission on that, that must mean an intention to cause injury. In other words, injury of the kind provided by the insurance clause. And on the facts of this case, we stand or fall on the facts of this case as to whether or not there was an intention to injure. But I don't think it detracts, respectfully. The point really that I started all of this with, I think, was the point that my Lord Legate raised, which was that extension 3 doesn't add anything for either side. And that's the point which I don't accept, because in my submission, there is an obvious purpose to extension 3. Quite apart from the non-bodily injury, we have a situation where then we're into non-intentional damage, where there's no intention to cause injury, but nevertheless, injury can ensue even with no intention in the course of the normal operations of door staff. And yet in that circumstance, the insurer is saying, well, okay, I cover that, but only up to £100,000. I'm sorry, I'm not sure whether my Lord Legate had also had his hand raised.
I just want to make sure I've understood what you're saying. Suppose you fail on the exclusion point in relation to the main claim for injury.
Yes.
You don't say, do you, that in that circumstance the extension has any relevance in this case? If the exclusion doesn't bite on the injury, it's not a deliberate act. That's the end of your defence, and the extension isn't going to help. Is that right?
No, in my submission, it could. It does have effect.
It could help.
Yes.
Well, that's what I don't understand. So somebody who's got the extension can, which is meant to be extra cover, they can end up being worse off, can they, in terms of their claim?
The employer, if one looks in this sense, my Lord, let me try, if I might, to explain it. Looking at what cover the objectively the insurer and the employer and the insured can be expected to have. They have the insuring clause that covers the vicarious acts of the employees. We then have the exemption clause in terms of clause 14, and your lordships have my submissions on that as a matter of law as to what it means in terms of the interpretation. But really what I'm dealing with is, let me assume that I'm correct on that as a matter of law, but I fail on the facts. In other words, there was an injury, but there was no intention to injure. There was no intention to injure. And in that situation, in my submission, a physical restraint in the course of the physical injury in the course of restraint in the wrongful arrest situation would, if there was no intention, could still be covered by extension 3. And therefore the employer is paying a premium in return for which he or she knows that he will not have cover if his doorman inflicts deliberate intention to cause harm. He also knows that in the course of restraint or assault, even if there's no intention to cause harm, there will still be a limitation on the cover which would flow from those type of circumstances.
So your contention is that if in this case, suppose on the facts, there was no intention to injure, and so the exclusion doesn't bite, the employer would have a good claim under the policy if he hadn't bought the extension for wrongful arrest, but because he bought that extension, he's stuck with a 100,000 limit. It can't be right, can it?
Well, I think your lordship's point. Of course, what we don't know is we don't know the effect of the extension. We don't know how that came about, what part of the premium that played. But I take your lordship's point.
If there are no more questions, then it remains to thank you, Mr. Mabrietti, and you, Mr. Milligan, and those assisting you for your submissions. This is obviously an interesting and tricky case. We'll now take time to consider our decision. The court will adjourn.